Okay, this is day 27, Karen retrial. This is Dr. Russell. She is expert witness in animal control, or not animal control, animal bites. She has seen over 500 cases of dog bites. She has co-authored specifically police dog bites. She dealt with bites that were caused by police dogs. She has dealt with numerous types of dog bites, and she has authored articles that was approved through the peer review process, so they're well established credibility articles. Her credentials of somebody as an expert who can author or co-author on such articles was established in the peer review process. This basically means that various medical professionals approve, so that not anybody can just write something. So her credentials was established when authoring that, and her experience and expertise was established when she authored that, with having, again, well over 500, hundreds and hundreds of cases. They settled on a number of cases to be over 500 or more. So this is the judge asking her a very accusing question. And the problem I have with her question, now I know they do have a lot of sidebars. I have not checked the record to see if something was filed, but I don't hear any objection from Jackson, which I find to be problematic because nothing's reserved for appeal unless there was a previous conversation prior to her presenting this. This is a voir dire because Lowley, with the audacity to accuse the defense of violating, the timely manner he's supposed to get things to the prosecution, is going to do a voir dire so that he can have an opportunity to question this witness or discover what, or basically have time to prepare. It's ridiculous the amount of non-expert people who testified during state witness testimonies repeatedly, over and over and over, have testified about the bite marks, which they do not have the expertise to be testifying about the bite marks. The defense has not received any notification that state trooper is going to be testifying about the bite marks. What they understood that they were going to be testifying about would be what their involvement as far as finding evidence on the scene or accident reconstruction, for example. You had various state witnesses testifying as if they were an expert. And even Lowley, in a pretrial hearing, opined, if you will, that they were not animal attack marks on the arm of John O'Keefe. So here you have an actual expert witness, an actual expert with specific experience in dog attack victims. She's an ER doctor, that were many of which were caused by police dogs, which means German shepherds. And she goes into detail about the different types of bites that are created by dogs, some that are more superficial than other. Anyway, she goes into great detail. So what does this judge do? She presents that somebody gave me information that you reviewed. You reviewed some records about Chloe. Chloe was the dog owned by Albert that is accused of attacking John O'Keefe and causing the bite marks. Either it was him that attacked him, maybe causing him to fall. I initially believed that the skull fractures was from him, the dog attacking him, and maybe he fell down a flight of stairs, and that can easily cause a fracture on his head. But after seeing testimony of Higgins and the things that he has done, and just so many things that has been revealed, the missing footage at the Sallyport, a cop that's going to testify stating that he was actually at that car. Anyways, I won't go into all the detail, but the point is, she accuses this doctor who rejects her accusation. She says, I have received information. Now, who provided the information? How would they know what this woman is reviewing if she has not even done a report to say what she has reviewed? So that was revealed that she didn't do a report. This was, she contacted, she'd heard about this case and the controversy about the dog mark, and so obviously she has that expertise. So she approached the DA in LA, who knows the defense. So probably word of mouth kind of deal. So they're trying to reject her because she approached them. They're trying to act like, oh, well, you sought her out. Well, because of the things Lowley's doing in the middle of the trial, which was established, last week, that he even admitted that he failed to give proper notice for. This is what she does. She accuses this doctor of having read reports about Chloe. Now, keep in mind, in case you did not know in this case, because this has not been discussed in the trial, if you watched the pre-trial motions, there was an investigation by the parent of Karen Read, who hired private investigators. They discovered that 2 other people had been attacked by the Alberts dog. And so there is reports about Chloe. And what this judge says is you're going to hear about those reports. Because before this witness came forth, nobody has heard, because it's not been allowed to be discussed, about the actual reports, that there are reports on Chloe. And the reason this is important is because when the Alberts testified, you remember there's a sidebar, they were trying to impeach them, basically, because this judge knows that the Alberts lied. That's my point to bring this out. This judge knows that there was incidents. The Alberts got on the stand and they were specifically asked if there was any incidents. There was an incident. They claim the reason they rehomed the dog was because it attacked another dog. And in actuality, that's not the truth. And but they specifically asked if there was any other instance, and they said that was it. It just a one-time thing where it attacked another dog. When in reality, it had attacked people and sent them to the hospital. So there's hospital records, and then there's reports on this dog. And so there was a dog fight where it did, but it also hurt the person in the process. It wasn't just the dog. But anyways, so for her to present this, I've received information that you read Chloe's reports about Chloe, and this judge says, or this witness says, no, I didn't do that. So instead, the judge saying, okay, well, I also received information about you also, you reviewed da-da-da. So what she does is she rejects her denial because of the way she words it. And this is very telling about this judge. When she says, I have received information that you read da-da-da-da, and she goes, no. And so then she says, I also received that you also read da-da-da. So when she says you also read, she's saying that you read this and this. She's rejecting her denial without even realizing that that's what she is doing. She's telling this woman, in her response to her denial of having read anything about Chloe, she's saying, well, I don't believe you, and you also read this. So watch very closely. I've got it muted, so I've got the closed caption on. Watch closely to how she words this. It's very telling. So she's talking about, yes, she can say with certainty that this was an animal attack. So she's another question. So I received that you also reviewed all reports associated with a dog bite prior history. See right there, Chloe has a dog bite prior history. See that? No, I don't recall ever seeing anything like that reviewed. Now look what she says. Submission for DNA testing. No, I don't recall seeing it. So she's rejecting it very clearly. So she when she's telling her opinion, she's trying to allege that you're looking at these reports, which are not allowed in this case, which is very problematic. To suppress that kind of evidence from the jury. And so, look at her grin on her face. She's just so condescending. In another question, so I received information from who? How would you know what she reviewed if she hasn't wrote down what she reviewed? See what I'm saying? That's very problematic. She rejects it. No, I did not review those. So also what happened today that is also relevant to this specific witness is that expert witnesses were hired by the FBI, not for the defense, so they can call them in there, but because they didn't accept or they suspected what the Commonwealth, what certain people who was prosecuting this case and investigating this case was not correct. So they hire their own experts and actual experts, not somebody with an associate's degree testifying about dog marks on the arm. And he, who only has an associate's degree, Paul, we'll call him Paul, testified about these arm marks specifically, and he does not have any expertise to do such. But this is what the state has been doing. They've been presenting people to be used as expert witnesses who are absolutely not qualified. So here's an actual qualified witness who has specific police dog attack expertise. She's seen hundreds of cases. She's treated cases. She's done research. She's authored by peer review articles. So she has actual testimony. So then she wasn't hired by the FBI though. So, but the FBI experts, two of them, testified today about the accident. He has PhD degrees, and this is compared to the states and this judge allowing somebody to come in who only has an associate degree, who is not only just his role is accident reconstruction, but when you have injuries of the arm and he's trying to be conclusive, he doesn't have the medical expertise to testify about those specific injuries, but he did. And so he's trying, this guy that works for the state's trying to rule out animal control, and he doesn't have the expertise to do that, but she allowed that. So here she is challenging her credentials, right? And just basically what she can, present as medical certainty, making up any kind of excuse whatsoever she can to exclude this person, right? And then so she accuses, that's what the accusation was about. Somebody, okay, provided information falsely accusing this doctor right here of having read Chloe's dog reports. But the problem with that is, where would she have gotten those reports from? Because those were not allowed. So she's trying to set up a scenario where somebody violated the law, violated the orders of the court, you see what I'm saying? She did. And then when she denied that, then she said, and also, so, it's just so obviously biased. So then when you have Lowley goes up there after the guy with a PhD testifies, there's two of them, okay, expert witnesses with several degrees, actual degrees. Not associate's degree is just your general subjects like, math, English, literature, and then a few electives. And so that's not even, it's like half of a bachelor's degree. It's very basic. It doesn't have anything to do with the specialty type of situations like accident reconstruction, medical examination, and determining what causes injuries. Those are required by people like this other expert who has a PhD, talk about kinetics and biomechanics, and he doesn't have any of that. So Lowley gets up there and he testifies, oh my goodness, that none of these are qualified. You're literally, this guy's not really, I think he doesn't think he's under investigation, okay? But if anybody that he is using is under investigation, then kind of sort of so is he. because there's improper things being done. And if Lowley knows about that, then he's violating his attorney ethics. And if he's hiding exculpatory evidence, that's actually criminal. So the feds sending a strong message to this court by allowing their witnesses who they hired for the investigation to be used. That's a pretty strong message. Like, hey, yeah, so let's see what you say about our witnesses. So here's Lowley, the DA, who's using bunk expert witnesses and attacking Cellebrite, by the way, who's an Israeli company, attacking Cellebrite as if they're bunk science, who the feds are using to this day in their prosecutions. And the Secret Service is the one that attacked Cellebrite for the first time ever, because Secret Service agents were accused of deleting text messages. And that was the first time ever that anybody challenged Cellebrite that I'm aware of. And so, but the feds, so you have Secret Service versus FBI and the whole Donald Trump thing about the incident that happened on January 6th where he allegedly attacked a Secret Service agent, or there was some kind of scuffle. And so they alleged that there was deleted messages by the Secret Service, and they were told to preserve that data because they were going to doing a system migration, and they didn't preserve it. So when you do a system migration, sometimes data is lost. So they accused Cellebrite of not knowing what they're talking about. Okay. Anyways, so now you have the FBI has their experts who are a PhD, and they were really good experts. They really were. And Lowley just gets up there and just talks nonsense. He says, well, none of them are qualified. I'm just like, oh my gosh. If I could be a fly on the wall of the FBI room who hired those experts, I would love to hear what they said. Anyway, so that's what the issue is here, though, with this one and these animal control records. I am so disgusted. I wish people would petition and unite, those who have, influence or whatever. Why aren't they telling people about the Judicial Removal Commission that she's clearly shown bias? She accuses this doctor of something, and of course the courts, it's not been revealed who provided this information. It must have been discussed in a sidebar, because Jackson's not even addressing this accusation of, well, I received information that you read reports about Chloe's bite history. Oh my gosh, she just told the world that Chloe has a bite history. Did you all catch that? So anyways, I think that today was very telling on what she plans to do. So she's not going to make her decision today on whether or not this expert's going to be allowed. All these are in voir dire. This isn't before the jury. So she's going to decide whether defense is going to be even allowed to have expert witnesses. And this is what I have said. If you go back and look at my videos, I have said all along, because everybody's like, just wait till defense gets on. Just wait till defense gets on. I'm like, you don't understand. They have voir dire their expert witnesses, and they're planning to not allow their expert witnesses, because how is the jury going to hear the truth via expert witnesses if they're not allowed? So that's what this is. This is, we're going to block your expert witnesses. And Lowley, mid-trial, filed a motion to block expert witness that he had already been denied. And I just personally felt like that was planned. Like, let them think all along that they're going to be allowed to have their expert witness, heck, them have their confidence, just wait till we get our defense on. We'll show them what's what, right? And then mid-trial, there's this accusation that he has violated, timely presenting to the Commonwealth rules. And Jackson, of course, says, no, that's not true, but this is what they do. They wait mid-trial, and then they blockade them. And then meanwhile, they've been presenting witness after witness after witness after witness, discussing those arm marks that don't have the expertise to do so. So anyways, I just ask for people, pray that the feds will prosecute. I think they have enough, especially with the HealthFit app. And that's a very concerning thing. I have talked about the HealthFit app data. I have a video of it where the expert witness, Richard Green, and they've been done nothing but attacking Richard Green, who is a well-established, far more experienced than they are about what's what on, the deleted text. But even if they don't accept the whole deleted text issue and the Google searches. The HealthFit app is not once brought up by Lally. He's not discussed it. If you notice throughout this whole trial, he's challenging everything the defense plans to bring. You have not heard once, unless I've missed it, him bringing up or challenging the HealthFit app data. And I find that very concerning because that's a part of Richard Green's testimony. His testimony is about the deleted text and calls by Jim McCabe, which they've attacked through their testimony. He analyzed the Google searches, and they were done at a specific time. He's going to testify to that. But then he also analyzed, the comings and goings of Jen based on, the phone data, and also the comings and goings of John O'Keefe. And that he arrived at specific coordinates, which was the address of the Alberts at a specific time. And then he got out of the car because you see movement, 267 steps going up and down flights of stairs. And then 7 minutes later, he walks 36 steps. And that's the last recorded movement. So you haven't heard anything about the Fit app. And I'm just like, I'm feeling like they're planning to block it. And that's how they win cases. It's not so much that they don't have, like a defense doesn't have evidence. A lot of times, this is what happens in our system, that experts get blocked by the state. And that's a lot of times how people get convicted. So people think, oh, they're convicted, that means they're guilty. But I hope that people see what they're doing here is classic example of how the innocent do get convicted. And so prayer is needed in this case. I believe in the power of prayer, and that's what is needed here. To, one, get the feds to actually prosecute for the various crimes that have been committed, and that means they have planted evidence. It's just so obvious. It's because that HealthFit app data is very telling. It destroys everything they've presented. And so just pray that all of their witnesses do get to testify, and that they do hold those who are corrupting the power accountable.